All right, well, welcome to our Globinar today on U.S. immigration update for international investors and businesses. We have attorney Matthew Myers, and Matthew is a board member of the Global Chamber San Antonio. We're glad today that we have this opportunity to have this expert who has really been focusing on the change and transition between the Trump administration and the Biden administration as it pertains to immigration policy and strategy. And so today I am joined with our chairman of the board, Jorge Canavati, who is a very robust member of the board who has plenty of international business experiences. And so today we're just glad to be able to talk with Matthew and really to glean some of his expertise in terms of what will help make you money as investors and as businesses. Matthew, thank you for joining us today.
Thanks for having me.
So we're going to jump in. I know that you have a slideshow, but can you just give our Global Chamber members a little bit about your background so that they can understand what type of law that you've learned and practiced over the years?
Sure. I practice in Texas, where I practiced for coming up on a decade now, exclusively business immigration, so work visas, investor visas. I started my career with one of the largest immigration firms in the country and decided summer 2020 in the middle of a pandemic was a good time as any to start my own practice. And fortunately have been successful and am enjoying myself being somewhat of an entrepreneur and understanding more what investors and entrepreneurs and small business people go through. So that's the focus of my practice and my niche within immigration law.
Okay, thank you. Chairman Canavati, do you want to?
My liege, yes.
Okay.
Yes, well, I'd like to, I hope that as we go into Matthew's presentation, I'm sure he's going to talk about the separation, if I may, of non-immigrant work visas, immigration, right, as into a green card, resident alien. Of course, we're aliens from Jupiter and Mars, and we all come in. And U.S. citizenship. There's a big difference between all this, and which the media bogs it down, confuses it, smoke and mirrors. The issue I want to touch upon, if we may, Matthew, the issue on the amnesty situation to clarify what is happening at the border. These are not people who are invading the United States. Just to get the facts and so we can have a base to have a nice discussion, right?
I think that's a good idea, and I know you have a lot of experience, so you'll be able to rein me in if I get away from the practical. But yes, I'll touch upon all of that, and I guess I could load up my PowerPoint slide right now, share my screen. That work?
That's perfect.
Okay. So I'm going to talk about ongoing pandemic travel related restrictions, then give a quick immigration 101, and then go through the non-immigrant and immigrant green card strategies and pathways for both U.S. businesses to hire foreign workers as well as international entrepreneurs and investors, and then we'll have a general Q&A, except for Chairman Jorge Canavati, who will be asking questions throughout.
I'll keep quiet.
Okay, so a lot of content on this slide. To summarize, because unfortunately the government doesn't put all of this on one website. They make you go to several different websites to figure this out. So general requirements to travel to the United States that are independent of the standard immigration requirements are generally travelers who are non-U.S. citizens or permanent residents must have COVID-19 vaccines and proof of vaccinations that are accepted by the airlines and by the United States. So there's kind of two layers there that practically you have to overcome. Then CDC for all air travel, so not land border travel, but air travel, negative COVID test is required within 3 days of travel. There's some go ahead.
Yeah, I just heard that they're about to implement 1 day of travel because of the Omicron threat now. That's about to come out. I just heard that yesterday. It's going to take 24 hours now, not 72 anymore, but 24 because of the new potential threat. I'm sorry, Mike,
No,
Matt.
no, I appreciate you raising that. These, there are changes made on a daily basis. And, you know, new legislation that gets passed by one house, and then it's enough to keep up with what's actually happening. But I would anticipate, as you said, there to be additional restrictions. And actually, with the individuals who are accepted from the COVID-19 vaccine requirement, there are additional quarantine and a 1 day negative COVID test required, different additional measures for anyone that's accepted from these restrictions. So it's kind of an onion that I hesitate to peel back completely without doing a case-by-case analysis. But I included a link, and I'm happy to share this PowerPoint with anybody, a link to the specific restrictions here. Then primarily the impact has been on tourism, but then not really. Mostly it's restricted asylum seekers coming up from Mexico. This restriction on non-essential land border travel between the Mexico, Canada, and the United States. There's a recent, in response to the Omicron variant, restriction on travel from the African countries listed here. For anyone who has spent time in these countries within the past 14 days of US travel. So if a person goes to Morocco, waits 14 days and then travels to the United States, this restriction wouldn't apply. And then there's some national interest exceptions and others that are exempted listed there. Finally, kind of a more general comment. Right now, there are significant delays in the immigration process generally, but most significantly at US embassies and consulates abroad, where visitor visas are often not processed. Renewals may be processed for visitor visas, and then there are limited non-immigrant or immigrant visa services, often with significant backlogs of, in some cases, 6 months or 12 months, whereas previously it would be a few weeks to get an appointment at an embassy or consulate. So getting into the basics though, I'll try to go through these 101 slides relatively quickly, but you know, when I talk to US citizens who have no familiarity with the immigration system, they think, well, either you're a citizen or you're trying to get your citizenship, and you know, there's nowhere in between. But there are a few categories of non-citizens. They're immigrants. These are permanent residents, or also called green card holders. Once you're a permanent resident, that status is renewed, kind of like a driver's license. You can be a permanent resident in the United States so long as you remain in the United States and don't commit any offenses that could render you removable. Generally, all the rights and responsibilities of a US citizen, except cannot vote. And so unless someone is from a country that does not allow for dual citizenship and the person wants to retain their citizenship, it's generally recommended to go ahead and apply for citizenship, because once you're a citizen, you can go live elsewhere in the world, or you know, and not be as concerned about the being removed from the United States or deported from the United States. Then non-immigrants are where I mostly make a living, and you know, business immigration attorneys make a living. These are distinct categories. by which someone must prove that they qualify to be here in the United States. And it requires, a lot of legal evidence and proof of that category. And not everyone fits under a category, and not everyone clearly fits under a category. So there's some gray areas. It's referred to as the alphabet soup of immigration. And these are approved in increments of 6 months to a number of years, and renewed, and each time proving qualification. Then other legal statuses that you may have heard of that are kind of they're kind of limbo statuses, essentially temporary protected status, DACA, international entrepreneur parole that I'll talk about. These aren't technically admissions to the United States. It's based on a legal fiction, with DACA being prosecutorial discretion, TPS being where the president designates a country as unsafe for their citizens to return. And then the international entrepreneur parole rule was implemented by the Obama administration, paused or stopped by the Trump administration, and then recently revived. And it's kind of interesting, and I'll talk about that more later. And then, of course, there are people in the United States who have no legal status. And as Jorge mentioned, there is in Congress a bill that passed the House that would create a pathway to permanent residency and citizenship for undocumented individuals who arrived before 2011. That has to pass the Senate, and measures of this kind get passed by one house and then don't end up proceeding, and get passed, don't end up proceeding. So it remains to be seen if we'll get significant immigration reform like that, which some people call amnesty.
Matthew, wasn't there under the Trump administration where there were certain nations that had like a favored country status, and so if I recall, there were some more European type of countries that had, I guess, a leg up in terms of immigration based off of how the United States ranked those countries. Is that true, or?
Not really. That may have been our former president's desire to favor those countries, but actually, from my perspective, the 5 countries that have the most benefits, the way our immigration system is currently due to treaties, the way that our system is currently set up, are Canada, Mexico, Chile, Singapore, and Australia, because they have a professional visa treaty, they have a investor and trader treaty, and actually European countries may have investor and trader treaties, but they don't have their own special professional visa category, which is interesting. I often get people say, well, they're from the UK, don't we like the UK? And I say, yeah, well, we don't have this special treaty with them, unfortunately. But yeah, definitely a good question.
Thank you.
So, Matthew, one of the most tedious and most bureaucratic processes that I went through in person in my life was the transition from the non-immigrant visa that I had 50 million years ago to the green card. That was a nightmare beyond anything I ever went through. Can you explain a little bit about that? I mean, the process in generally, and then when I became a citizen, I did that myself. I did the application myself. That's an old no-brainer. But the process, when you state your intentions of staying, right, after your non-immigrant visa, when they don't want to renew it anymore, and they say to you, you either leave or you state your intentions, right? That process, can you talk a little bit about that, please?
Yeah, and it was something that I I include sometimes in these presentations, but it's kind of lost on some, is during the Trump administration, they removed the deference to prior decisions. So when someone was approved on a visa and came here with their family, say a TN visa under the NAFTA agreement, came here with their family and if essentially were authorized to be here for 3 years. At the end of that period, the government was not required to give any deference to that last approval, meaning this person's family, even if they're renewing the same visa, the family and everything is in jeopardy. They're engaging completely in de novo review, whereas previously there was some deference given to the last approval. And that was added back in by the Biden administration and substantially decreased the number of denials due to that deference. So that was a major impact and stressed a lot of people out, reasonably so, because the Trump administration was being sued left and right for going outside of the law or imposing scrutiny that was more beyond a reasonable doubt than the legal standard for immigration cases, which is generally preponderance of the evidence, slightly more than a 50-50 coin flip that the person qualifies. Now, I still think it's that the immigration authorities are closer to requiring a beyond a reasonable doubt standard, but that's particularly stressful when you've been approved once, twice, 5 times before for your current status.
Yeah.
Nothing's changed and they're able to just deny your case. So fortunately, things are getting better. Biden's working on ways to speed up immigration processes that were slowed down intentionally so by the Trump administration, frankly, relatively brilliantly by Stephen Miller to slow down the process, scrutinize the case.
I tremble when I hear that name.
Right.
So and what you just mentioned, is that the same situation for the H1 holders? Because I was an H visa and I still had to prove, right, that there was no one else in the United States that can do my job. You had to go through this whole process.
Yeah, so I'll talk about H1Bs in perm as well, which it sounds like you might have gone through that process.
Yeah, I went through that process. That's the process I went through.
So those slides are back to back, so we'll get to those too. So this is, I won't get into it, but this is just the common non-immigrant visa categories for businesses or business people to use. And there are categories to be a non-immigrant and then to obtain immigrant status or a green card. And once, as I said, once a green card is obtained, it doesn't have the same scrutiny in terms of renewal as non-immigrant visas. Once we get over the hump of getting the green card, which is usually more difficult and more expensive, then it's all downhill, as Jorge said.
Right.
So common process, if someone's outside the United States, an employer or petitioner files a petition with the government inside the United States, and then the employee or investor applies for a visa at a U.S. consulate outside the United States, and then travels to the United States and seeks to be admitted to the United States by U.S. Customs and Border Protection. There are some exceptions to this, for example, treaty visas, TNs, and then E1 treaty trader, E2 treaty investors can go directly to step 2. And Canadians are visa exempt, so they can often skip step 2 and step 1 in some cases. And so during the pandemic, this is just to show when people were in the United States, we had a lot of business visitors who said, you know what, I'm not leaving. I want to change my status from within the United States. And so that's what we did. And, some are still waiting on a visa interview appointment at a consulate if they want to go to that, or they're still waiting it out. And so things changed a little bit with the pandemic. This document most people are surprised to know that we have the USCIS approval, we have the visa stamped in the passport, but the actual document that matters above all and controls immigration status is what CBP at the airport or the border enters into the system, which is that top document, or what, when you file a change of status from within the United States, what USCIS issues at the bottom of your approval notice. And CBP makes mistakes, which they sometimes blame on the airlines, but either way, this is the controlling document. And sometimes they admit people as a visitor when there should be work authorized. Sometimes they accidentally admit them, or they purposely admit them for less time than someone would anticipate. I had a case where everyone in the family was admitted for 3 years, but the child whose passport was about to expire was only admitted for 1 year. And this was not, accessed online and reviewed by the person who contacted me. Freaked out that his child had overstayed by 1.5 years, technically, and so we had to resolve that.
The infamous I-94.
Yeah, and they're not, it's not commonly known that that's the controlling document when someone arrives, and so definitely recommend.
And it's also the, many people believe inadvertently that many undocumented folks are ones that slip through land borders and stuff, and it's a lot of folks that just overstay the I-94. That's where most of that comes from, but again, it's a matter of status. You're not gonna look at a neighborhood with a $500,000 house for someone that overstayed his visa, right? You see, it's a status thing. It's really screwed up.
Yeah, I think it's about 50-50 visa overstays versus people crossing the border.
Yeah.
Yeah. So I have here, the common kind of high level, and I'm going to get into the nitty gritty, but high level common business immigration pathways for international entrepreneurs and investors. It's very common to come to the United States, review the opportunity for investment, the landscape, market, and make connections and have conversations before making an investment or before moving to the United States. Then once the decision's made to do that, they would transition to typically first to a non-immigrant work visa, and then eventually at a later date to an immigrant visa or permanent residency. A common situation that I see occur would be someone who is here on who has a business in Mexico, expands to the United States, that business in an L1A new office context, or because Mexico has a investor treaty, comes here on an E2 visa, a treaty investor visa, and then the pathway to permanent residency is commonly EB1C for multinational managers and executives. A lot of people hear about EB5, and we'll talk about that, but EB5 can take anywhere between 5 and 10 years in total, whereas EB1C is between 1 and 2 years, and and has similar requirements as the L1A. It's much more straightforward, but does require practically not written in the law, but I generally see that they want to see that the person had at least 10 employees that they oversaw abroad, and that the U.S. company has at least 10 employees that they oversee. But that's required anyway of the EB5 for a U.S. company. So, but may not be initially viable for an entrepreneur to go directly to permanent residency, because you need an entrepreneur to be in the United States working, needs to have some sort of work authorized status, and waiting outside the United States for 2 years and growing the business without you is often not viable. So there's often a short-term strategy, and then a lot of the non-immigrant visa, and then a long-term green card strategy.
Right, right.
Then for, for U.S. businesses hiring international workers, which may be the U.S. business that the international entrepreneur or investor started, but it's common for international workers to, they could never have been in the United States. They could be in Mexico receiving a job offer, or any country around the world. But it's very common for there to be a student that once they graduate, they find a job with a U.S. employer who sponsors them for a work visa. H-1B is the default work visa, and then the other visas listed are also options that I'll explore in greater detail later. And then the permanent residency process, the default is called perm labor certification, where the company tests the labor market to confirm there's no willing, qualified, and available U.S. workers. And that's EB2 and EB3 preference categories that I'll again talk more later about it. And then after 5 years of permanent residency, an individual can qualify to apply to naturalize as a U.S. citizen. Although I have many clients who, for strategic reasons, stay on non-immigrant visa. They don't want permanent residency for tax reasons or otherwise, or don't want citizenship for similar reasons. So that's just the options that exist. And as Jorge mentioned, the naturalization application is typically straightforward, as long as there's no issues in the past. So some people handle that on their own.
Funny thing though is that the IRS doesn't really care. The IRS, you're here 6 months or more, come to Papa. And right, go ahead. I'm sorry. Go ahead.
No, I just was going to say I appreciate you raising that. I am not qualified to talk on tax, but yes, to be clear, I believe IRS is based on physical presence, not immigration status. Although permanent residents are not allowed to file as non-residents at risk losing their residency. So
that's right. I mean, ever since I had my work visas, I filed taxes like anyone else, period. When my dad had my dad would visit on business when we had these offices here, but he kept a very, very, very detailed file on his airline tickets, his entries, his exits, right? And would give these to the accountant precisely for this reason, because he would have been taxed if you're here more as a U.S. person.
And one thing that's nice, although it's not entirely reliable, is that U.S. Customs and Border Protection is starting to do a relatively great job at tracking entries and exits. So that's also evidence that you can pull up, or a non-U.S. citizen can pull up when they're traveling, after they travel internationally or now. CBP has that information readily available in their system if you input your passport information. So that's helpful too when I have clients who don't remember their entries and exits, because that's something that is on the naturalization application and does become important for certain visas that have a limited number of years that you can be in that status. So back to your standard international entrepreneur or investor coming to the United States to start the exploration of the U.S. market, commonly done as a business visitor. And I'll talk about what's permissible to be, what can be done as a business visitor. But of course, this is not a work visa. Remuneration from a U.S. source is generally prohibited, with some very, very limited exceptions. Non-immigrant intent is required, which means that the person maintains an unabandoned residence abroad to which they intend to return, and they could be questioned on that at the consulate or when they seek admission in the United States. The time period in the United States is determined by the CBP officer, which is up to 6 months. And I have clients who are from civil code, Napoleonic code countries like Latin America and Europe, who think, well, it says 6 months, I'm entitled to 6 months. Why did they only give me a week? Or, what's going on here? And so there's an additional common law, know it when you see it test, which is to continue with this example, people that travel a lot, especially when they're trying to get a business going, they spend 6 months in the United States, try to step out for 1 day and then try to come back in for another 6 months. But the CBP officers, you're supposed to maintain that non-immigrant intent, and they say, look, you've been here for the past 6 months and you're requesting another 6 months. You don't really live in your home country. You're living here. What are you doing here? And the risk of denial after a lot of travel for a large duration is high. And they can expeditedly remove people, which is a form of deportation, and with a 5-year ban on immigration benefits. So definitely something to be careful with and to strategically plan business travel while the business is getting set up. A visitor visa is obtained generally at a U.S. embassy or consulate abroad, unless the person is from a visa waiver country and they qualify, or are visa exempt, which is only Canadians are visa exempt. But the visa waiver entry is limited to 90 days rather than 6 months, and does not allow for a change of status. So physical visa is needed, which means that the U.S. consulate has undergone all of the background checks on the person in order to allow for a change of status. So
Right.
I've listed some permissible business visitor activities. A lot of my, it's not permitted as a visitor to Mexico to sign contracts generally, and so a lot of clients are surprised coming from any country of the extent of what they're allowed to do to get a business set up. Not allowed to operate and run the business, but our investor visa laws contemplate that business visitors are coming to the United States to get everything set up, to sign leases, sign contracts with customers or vendors, secure funding, meet with lawyers, accountants, and other advisors to get everything set up. As long as they're not practically working or operating the business, that's generally fine. So then the default, what I call the default investor visa that doesn't require a treaty with the United States by the person's home country, is the L1A multinational manager executive visa. This is basically an intercompany transferee visa. So if a business person has or is employed as an executive or manager at a business outside of the United States where they've worked for at least 1 year, then they can come to the United States to open a new office or to expand an existing office inside the United States. But this is problematic for the entrepreneur who wants to close their business abroad and move completely to the United States. It's just not possible on the L1, but it is on the E1 or E2 that I'll talk about next. And I mentioned there's a pathway to permanent residency that has nearly identical requirements, but more scrutiny and I guess more employment and management is recommended to be shown, called the EB1C. But the person doesn't need to get an L1A visa to go to EB1C. They can have an E2 visa and go to EB1C. They're distinct. So you have to have a non-immigrant pathway and then an immigrant pathway if you decide to pursue both.
I'm making so many notes here, Matthew. It's ridiculous.
Well, I guess that's a good thing. So here's a pretty slide with all the countries that have E1 so E1 and E2 treaty countries. E1 is treaty trader. where there's a substantial amount of trade between the person's home country and the United States. And then E2 is treaty investor, where there's a substantial investment made by someone from a treaty country into the United States. Some have both, some have one or the other.
So Matthew, this is probably what I was referencing in my previous question, and just to see, which countries are able to get a higher level of treaty status. But I guess those are issues that are worked out between the governments and is somehow approved within our United States government.
Exactly. And so during the Trump administration, New Zealand was added. There are a lot of European countries listed. Typically where developing countries are listed, we're happy to take their E2 treaty investments. Here's a list, but it's kind of a good cross section of the entire world. There's not really a bias other than the fact that the State Department's negotiated an agreement, a treaty with them to provide for these options. Iran was on the list until the Trump administration, actually, for example.
That's a story for a different time right there.
So there's a lot of content on the slide. For E1 treaty traders and E2 treaty investors, this is for both the principal investor as well as managers, executives, and essential skills employees. So it's very common for a company to start up in the United States and then bring over their key personnel. So not a client, but here in San Antonio, Toyota, opened their plant. And I would imagine, without knowing for sure, that they brought in a lot of their managers, executives, and essential skills employees, especially to get the business set up when they first opened here. And so that's how they would have done it. And so there are a lot of foreign-owned companies out there that are utilizing this status, but everywhere from a very small company to a very big company like Toyota. This does not require, though, like with the L1, that there's a business that exists outside the United States. It's helpful, but not required. What it requires is that the U.S. company is at least 50% foreign owned by a company or individuals with the citizenship of that treaty country that are not U.S. citizens or permanent residents. And then the employees who are sponsored must share that citizenship if they're planning to obtain E1 or E2 status as an employee of that company. And basically the difference between the two is one is substantial trade, one is substantial investment. This is another thing, people want a specific number. And I would say at least into the six figures as an investment. And it has to be made at risk. So it can't just be putting 100 grand into a US business bank account. They want to actually see that that the business is basically ready to operate when the person arrives in the United States, that all the investments have been made. And go ahead.
No, do you have to show yearly P&L statements, tax returns, to show the authorities that the business is healthy? That's a question.
So there's the initial application, which does not have the same scrutiny or requirements, but they do require a business plan with 5 years of financial projections. Generally, each consulate has minor tweaks to both formatting and what they require as proof for each of the elements of each category. So once the business is established and has been in operations, they do require or request tax returns. The visa that's issued, this can be applied at the consulate. The visa that's issued can be anywhere between 1 to 5 years. And so they certainly expect when you come back to renew at the consulate to see that the business has succeeded, the investments maintained, or
Right.
else the person no longer. And I guess another aside is that people are issued 5-year visas. They come to the United States. They think they're here for 5 years, no matter what they do. But the moment that if the business is sold, they're out of status.
That's right.
You're only in status. You're only complying with the immigration laws as long as you were engaging in the activity that the visa was issued to you. So that's something to be careful with, of course. And so sometimes with these cases, we have entrepreneurs who want to get into a number of different ventures. And so we structure it with a holding company and then different subsidiaries for what they're interested in getting into. And then we are fully transparent with the government that this is the goal. They're in, these different businesses and they're thinking about getting into these other businesses and with a catch-all so that that gives them more flexibility to do whatever they want to do.
So what happens? I'm sorry, go ahead. I'm sorry, Matthew, go ahead.
I had a question.
Chris.
Yeah. So when we're looking at immigrant entrepreneurs from non-treaty countries, like that list that you just showed on the previous slide, that's a small percentage of the actual number of countries around the world. So, so when I'm looking at go to the map with the flags, when you're looking at say Nigeria, say if you had a Nigerian entrepreneur who wanted to try to use the benefits of in your next slide, the treaty, there is no treaty for Nigeria. So what provisions do they have to use a visa or not? Is my question.
This is basically why I call it the default. It doesn't need, you don't need a treaty. So they would have to essentially, again, have to is a strong word, but this would be the main option that we would review. Another thing is that there are certain countries like Nigeria, Iran, Pakistan, other countries where there's a higher level of scrutiny at the consulate, whether or not the person qualifies. There's a level of scrutiny, both with terrorism and then also fraud that they impose. So that's another level to get into, but it makes it more difficult. But this would be what they would need to do, and it's often a pain, to use a technical term, for them to maintain, especially for entrepreneurs, to maintain a significant presence doing business outside the United States. They want to just open up their own, they want to open up a new business. They want to move to the United States and open a new shop or start a business without having to keep that maintained abroad, which is what the E1 or E2 allows, but not the L1. And so I guess that kind of leads into, I know Jorge had a question though, but that kind of leads into.
Just as a follow on, just to say that, so under the Obama administration and now the Biden administration, they've continued to work with the Young African Fellows Leadership Initiative or the Mandela Fellows Program. And that is a look at African nations and their entrepreneurs. And so when I think about the initiative to show young African business leaders how we do business in America, or to encourage them to do more with the US, then I don't see their countries. And so therefore, it seems like there would also need to be a pathway made to bring those respective countries into a treaty that would allow them then to have that robust relationship with the United States moving forward, or else they'll be on that pathway that you just showed, where there's more of a grind and not necessarily any real tangible guarantees as the people who have the treaties.
Yes, that
Can you repeat that, please?
Hey,
well,
hey, I said a mouthful and you impressed myself.
I'm shocked. I was impressed.
I think that pursuing an E1 or an E2 treaty would be, there's so much diplomatic efforts and bureaucracy behind that, but that, would be the way to facilitate trade or investment between the United States and African countries.
Matthew, forgive me, we have questions.
Oh, okay.
Okay, we have a question from Donaji Montes, and the question is this. Hi, Mike. Thank you for your amazing presentation with value and detailed information. I have two questions, she says. About the E1 is that you said the company should be at least 50% foreign owned. I have an LLC. I am Mexican, and I had that status for 2 years. I understood I needed to trade with Mexico for more than 50%. Did I misunderstand it? Right?
No, that's correct. So I kind of am trying to go through this quickly. So substantial trade is defined as the majority of the trade is between the US and the treaty country, and the trade itself has to be substantial. So I got a report from an immigration lawyer who said that they had a case denied, and so these cases can be filed at the US consulate in Monterrey or Tijuana. And he said his case, $250,000 worth of investment, and it got denied, which was kind of shocking because I would say, $10,000 a month with a number of transactions on a monthly basis is generally kind of my baseline for that. But he's definitely right that the legal qualifications for E1 really focus on trade, whereas E2 focuses on the investment being substantial. And it also, E2, some people mix these up, but E1 doesn't have a requirement that that there be an investment in the United States, or that it not be quote unquote marginal, but the E2 does. And how that's interpreted is hiring one US worker. If you're pursuing E2 status,
right,
it has to, marginal is supporting more than just the person's family and themselves. And so you show that by supporting the hiring of a US worker. And so that's part of the E2 process.
Excellent. There's a part two to this question. Ms. Montes says, I'm exploring reapplying for the E1 or apply for the first time to the extraordinary skills one in order to create a pathway to the green card. What would be your suggestion? This is a very, very good question.
It's so tough to talk, case specific. I mean, E1, and I don't know if he was talking about O1, alien extraordinary ability. There's, I guess I'll talk about the permanent residency strategies later, and that may help. But both are non-immigrant visas that don't allow for immigrant intent, and going from one to the green card strategy, it's a different green card strategy that we have to prove that the person qualifies for. So it'd be, different considerations there.
Excellent. How long is the time between, let's say you're an E1, E2, right? And when can you say, I'd like to apply for permanent residency, or I'd like to apply for immigration status, permanent residency, or green card? How long would you need to have those visas?
Theoretically, you could apply on, before or the day after. I suppose the holdback is E1 and E2 are non-immigrant visas that don't technically allow for immigrant intent. And so there are ways to pursue a green card. For example, I have a client who got a 4-year E2 visa. He's from Mexico, entered the United States. It's presumed entry fraud if you apply for a green card within 90 days of admission. Right. So on the 95th day, we had already filed a EB1C petition for permanent residency. but we waited to file applications for green cards until after that period where it's presumed entry fraud. That rule of that presumption of entry fraud is written into the Foreign Affairs Manual, but it's debated as if it's a rule or not. But I just avoid that problem altogether. And the original intention when he entered was to pursue an immigrant visa at the U.S. consulate, which does not raise, immigrant intent issues. But his daughter was going to age out. She was going to turn 21. And so we decided to apply for green cards. But that is because it's a non-immigrant intent visa, and you may hear about this as well. It's not recommended, and in fact, shouldn't travel internationally when you have a adjustment of status green card application pending, and you have a non-immigrant intent visa, because if the person leaves on the E2 visa, the adjustment of status can be abandoned, and also they may not let him back in because he's demonstrated immigrant intent.
Right.
So probably TMI, but
no. This is very important. So let's say I have my E1, E2, I have my $10 million business, and I want to retire. So I want to sell it. However, I can't do it on that visa. So I would go through this process you just mentioned, right? Get my green card, then sell the business.
The intention up until the issuance of the green card is to do what what you're promising to do, which is be a multinational executive or manager in this example. But as soon as the green card issues and it's in the hands, then the person can make any can take any action essentially that they want, so long as it doesn't conflict with what they said in the past. So some people say wait 6 months, but yeah, so that happens a lot as well with people that are being sponsored for permanent residency as employees. They say, can I quit? Can I quit the day after I get my green card? And again, a lot of people say wait 6 months, but there's there's no real answer. I'll kind of breeze through.
I had a very important, my employer was, no one can have a better sponsor than my employer at the time. That was the Port of Houston Authority. And they sponsored my visas and my green card, and I left the next day. No, I'm kidding. I stayed with them for a long time because I was there for a purpose, right? It was a lot of fun. It was a lot of fun those days.
Attorney Myers, we want you to go ahead and press through your remaining presentation. Yeah. We're getting close to the top of the hour.
All right, so this is the shut up Jorge moment. Okay.
Yeah, so
got the message, yes.
So I'll kind of breeze through the international entrepreneur parole rule. It's kind of interesting. It's for honestly, it's for the cases where people don't qualify for a frankly more straightforward or more parole is a legal fiction that allows someone to enter the United States, but it's not a lawful admission. It doesn't allow for a change of status. It does allow for an adjustment of status. It's kind of a limbo status. And so if someone qualifies for another visa, I generally recommend applying for the visa. But where that's not possible, I won't get into all the requirements that are listed here, but basically this predominantly benefits startup companies that have angel funding and serious investors in the business. And, this is to facilitate those types of startups to get status here. And the example I give is that the founder of Zoom, I read he was denied 6 to 8 times under the H-1B visa lottery. And I guess he persisted, but a lot of entrepreneurs give up and open their businesses outside the United States, which means the United States doesn't get that economic benefit. And so this is kind of a catch-all for that. H-1B is the default. I talked about the default investor visa. H-1B is the default professional visa. that requires that the person have a bachelor's degree in a specific field, and that the job requires a bachelor's degree in a specific field. And it becomes complicated for business administration degrees, for example, and some more general degrees. And among the requirements are that the person be paid a prevailing wage, which is based on their occupation, the level of their experience, or the job, what the job requires. Is it entry level? Is it more senior? And then the area of intended employment. Someone in San Antonio is likely paid less than someone in Los Angeles, for example.
One of those.
And then the quota for new visas is 65,000, with an additional 20,000 visa quota for those that pay a U.S. university for an advanced degree, to kind of encourage that. And there's a electronic registration process that has been undergone for 2 years now, which made it a lot easier for employers to sponsor H-1B, because in years past, employers had to pay people like me to file the whole case, only to find out that the whole thing was rejected in this lottery. Whereas now it's an electronic registration process, much simpler, a few-page form. It doesn't require a business immigration attorney to prepare the entire case. This is, what the process looks like, with a lottery every March, application window from April 1st through June 30th. And then last year, they conducted a total of 3 lotteries to make sure that they used all of the available visas in case people didn't apply. They really made sure last year to use all of them, which was great, because cases are denied or people choose not to file, etc. And so it's for an October 1st start date. So a lot of people are shocked when I tell them now, so it's a lottery. This is the only option that's available for your employee without getting very creative. You can wait, 10 months to hire someone, right? And by the way, it's a 25% chance that it'll be selected in the lottery. So fortunately, it's not as expensive for them to try. And unfortunately, there are a lot of employers with the labor shortages, and without getting into the politics of whether people should be paid higher or whatever the reasons for the labor shortages, there are labor shortages, and employers are, at least the ones that call me up, are desperate to hire. So these are the treaty. I've listed some treaty-based professional work visas that I mentioned: Canada, Mexico, Australia, Singapore, and Chile are the 5 countries that have this additional work visa category. There are other work visa categories that I'm getting into that are for, seasonal agricultural workers, seasonal non-agricultural workers, etc. And then I've talked, the L1 that I mentioned earlier can also be used for specialized knowledge employees. And I have talked about the E1 and E2 for employees. And then certain individuals can qualify as an O1 alien of extraordinary ability. So I got 2 minutes. The default permanent residency process, as touched upon earlier, requires a formal test of the labor market. It takes right now, it used to take maybe around a year. Now it's taking around a year and a half, after which the employer can file an immigrant petition and whether, if the person's inside the United States, an adjustment of status green card application. It's less common for someone to do this while the person's outside the United States, because they have to wait that year and a half for the test of the labor market, and then additional 6 months to a year until the person gets an immigrant visa at the consulate. And so most employers, in my experience, aren't planning 2.5 years ahead unless they really know and like the person at their overseas operation. But most of the time, someone will come here on one of those non-immigrant visas that I talked about and then be sponsored. This is only for, this is not for owners of the company, though. For owners of the company, there we've talked about EB1C, and then a self-petitioned national interest waiver petition can be filed, which basically means don't make the company or the individual file or go through the whole process to test the labor market. Waive that because it's in the national interest. And so I talk about this here about if it's in the substantial intrinsic merit, benefiting the economy, job creation, environment, medical, etc. And then EB-5, $1 million investment. There's a lot going on with this right now, or lately. The regional center program, of which many people applied under, lapsed and was not reauthorized since June 30th. And there were changes that were made to the program, increasing the investment thresholds from $1 million to 1.8 million and 500,000 to 900,000. And those, because of litigation, have basically got struck down. And so this process, albeit a well-known visa or immigrant visa category, can take anywhere between 5 to 10 years. It's quite expensive. And so whereas some people really push this visa or this category, it's my break glass in case of emergency, because oftentimes we can find a quicker path and cheaper path. Cool.
I hope our folks are writing this down. We appreciate you, Matthew. I was muzzled, so I had more questions, but we'll talk about it some other time.
Well, I don't know if we've got to cut it off, but I'm happy to hang out for a couple minutes.
Yeah, I don't see any other questions online here.
Well, this
Chris?
this is great. So we got Matthew's telephone number, his email, and his website right there for you. If you would like to use his services, I'm sure he wouldn't turn you back. So please reach out to our chamber member. And again, we really appreciate the time that you spent with us. You can do end of screen share at this point. And let's see, Global Chamber. All of our events are online at globalchamber.org. And you can go to the tab and look at the events right there, just like today's Globinar with Attorney Myers. And again, our role is to help you to make more money for your business and to know exactly how to plot and plan strategies that will be winning in a global marketplace. So again, I'd like to thank Attorney Matthew Myers. I'd like to thank Chairman of our Global Chamber San Antonio, Jorge Canavati, and then also the support from the Global Chamber team, Cesar and Doug. And thank you all for attending. We look forward to seeing you on our next Globinar. This ends our presentation.
Thank you, Chris. Everyone have a good weekend. We have a note from Erica Edward. Thank you for this valuable content. It is greatly appreciated. And I'm sure she speaks for all of us.
Thank you all for having me, and I enjoyed it.